Good day, everyone, and welcome to our February edition of the Legal Issues webinar. We have quite a bit to go over today. We're, because of that, going to skip the legislative report. We will do that in the next committee phone call that we have. And here are the topics and the speakers today. To save us some time, what I'm going to do is I'll let you look at that and not read all of that so we can get through the materials. What I'm going to do at first is provide a brief update on what's going on at the Bureau. I'll mention some things that Michael Flynn will get into and Chris Culley will get into in greater depth. Then we'll also have an employment presentation and really two presentations dealing with COVID-19 and a bit on the QM rules with Chris Culley. But with that, let's go over with an update with the Bureau. And what we do have now is we have new leadership at the Bureau. Acting Director David Wago is the way that is pronounced. He has been with the Bureau for quite some time, never really in a consumer-facing position, though. He's been more internally administrative functions. And we have a nominee for the new director, Rohit Chopra. Now, he cannot serve as acting director because under federal law, since he has been nominated for the permanent director position, he can't serve as acting director. So that's why there is an acting director in that role. And if you look at Rohit's resume, he is a consumer protection guy. There's no question. He was at the Bureau originally. He then left, went to go to the Consumer Federation of America as a senior fellow. Then in 2018, he was nominated to serve as FTC commissioner in one of the Democratic positions, where he serves now and will be moving over from there to the Bureau. So this is clearly someone who's focused on consumer financial protection. And it is believed, former Director Cordray thinks he will be quite quickly confirmed. Remember, he was confirmed as FTC commissioner, so that it usually means it's could probably be an easy way for him to get confirmed as CFPB director. One thing we expect to see, in addition to more aggressive actions and enforcement actions, he does believe that regulatory enforcement and even litigation when necessary is appropriate, not only to achieve consumer protection, but to have a level playing field among industry participants. Significantly, he'll probably want to cooperate more with the FTC, and there may be incentive for the FTC to do that. There's a Supreme Court case now that's addressing whether the FTC, through its Section 13 authority, which gives it injunctive relief, has the authority to seek monetary relief such as restitution. Oral arguments were held on that, and not looking good for the FTC. Breyer and Kagan, two of the more liberal justices, seem skeptical at the FTC's position, along with the conservative justices. So if they lose that ability, according to Supreme Court ruling, they will have a great incentive to partner with the Bureau. And we expect they'll do that anyway, given his service as FTC commissioner. A commissioner. Now, let's take a look at the areas of focus. And two, none of these should be a surprise. COVID-19, and again, we'll get into that more in depth, but COVID-19 and the financial hardship caused by that. Racial equity, broader than just fair lending, which is our area, clearly fair lending, fair housing, but they're taking a broader theme in terms of racial equity and all aspects really of consumer financial protection. A couple examples that the acting director cited as troublesome: servicers not following the CARES Act and not giving information to consumers in accordance with the CARES Act. You might remember over the summer, the Bureau and the CSBS, I don't know if it was a warning shot across the bow or into the bow, telling people they were going to look for this and focus on that a lot. And again, we'll get into that more in depth. And also companies not complying with the Fair Credit Reporting Act provisions. So those are things they cited as something they're going to look at. He's directed internal administration to focus on errors found in exams and to bring about remediation. And companies that haven't heard from the Bureau yet will be hearing from the Bureau. So that it's pretty clear what his focus will be. Now, another thing he did, and this was just last week, he came out and we look at the next slide where it addresses a statement regarding consumer complaints. The Bureau views consumer complaints as very important and expects companies to respond to them. What they say is, we think companies have been lax in responding to consumer complaints. So those, particularly those involving the CARES Act, are going to be something they're going to look at. He's also heard from consumer groups that have said there is racial disparity in responses to consumer complaints. So he's asking for a study of that, and companies that appear to have this we'll be hearing from the Bureau. So these are things, really take out your complaint management system, dust it off, make sure you're properly first identifying complaints and then properly and diligently responding to those complaints, and have them looked at for fair lending purposes. Probably second reviews may not be a bad idea in some cases. Now let's look at next slide. Just briefly, we'll go into the regulatory freeze. We know President Biden has announced that for rules that are not yet effective, consider delaying them. That's hard to delay a rule that's been published in the Federal Register. You can't just delay it. You have to go through notice and comment rulemaking. The thought is give this administration some time. If a rule is considered to present significant questions of law, fact, or policy, they should really pull back on the rule, go to the Office of Management and Budget and get direction from the Office of Management and Budget, and rules sent over or not even sent over to the Federal Register. If they've been sent over, not published, take them back. If they haven't been published, you're going to sit on them for a while till someone appointed by President Biden reviews the rules. So what is that in terms of for our world? Well, the QM rules, which Kris is going to talk about, which are scheduled to become effective March 1. There's that recently, the HPML rule, the exemption for certain insured credit unions and banks that meet certain conditions from the escrow account requirement. That hasn't even been published. It's not controversial, though, and it's mandated by the Growth Act, published in 2018. That's going to go forward. What this will delay probably is the LIBOR transition rule, and the industry had asked the Bureau to give a lot more guidance on that, and we may have a delay. Now, fortunately, the longer-term LIBORs are now going to stick around till June 2013, not just the end of this year, so they can delay that, and it won't be the end of the world. Let's move on now. Take a look at one other area, and these are the rules that I just went over and were affected. Again, Kris will talk about the QM rules. For what it's worth, I don't know if it was Friday or today, the Bureau has that interactive website that has all the regs on it. They posted the March 1 QM rules. That, a couple bucks, may get you coffee at Starbucks. I don't know what you can read into that, but it's up there now. And let's go on now, slide. Just a couple of things I want to quickly mention. As a task force report came out early January 21, this was somewhat controversial, just having the task force. One of their recommendations is that mortgage brokers and mortgage originators be allowed to what? Sell packages of settlement services. For those who have been around a while, HUD proposed that in 2002. They recognize the HUD proposal. They don't know what led to the death of the HUD proposal. And this proves the adage, if you don't learn from history, you are condemned to repeat it. Every other single settlement service provider in the industry, other than lenders, attacked that proposal. I don't see that's ever seeing the light of day. Also, they issued guidance on limited English proficiency. Very helpful, not mandatory, but giving you rules of the road to avoid UDAP and other violations to make the intention clear. Will this administration pull that back and revise it? We'll have to wait and see. That concludes the presentation now, and I think we're now moving on to the QM ruling. Kris, take it away.
All right. Hi, everyone. I'm Kris Culley from Mayor Brown in DC. Unfortunately, not in what I hope is sunny California. But I wanted to update you on the pending rulemakings relating to which rules will constitute qualified mortgages, QMs. And as such, they enjoy that compliance certainty with federal ability to repay rules. So I'll just dig right in here with a focus on the changes to the general QM definition. Up until this recent rulemaking, as you know, in order for a residential mortgage loan to constitute a QM, the debt to income ratio for the loan must not have exceeded 43%, or else it had to be eligible for purchase by Fannie or Freddie. So under the CFPB's QM rulemaking, the DTI threshold will be eliminated altogether. However, in order to make a QM, the creditor still must consider DTI or residual income and must retain documentation of that consideration. In addition, the creditor must verify the income and assets that it considers, still using third-party documentation. But now if the creditor wants some compliance certainty with that aspect of the requirements, with the verify requirement, it can opt into a safe harbor by using specified verification guidelines of Fannie, Freddie, or one of the other government agencies. Those are all laid out in the regulation. So a lot of the questions I've gotten with regard to this new QM is really how to document that you've considered those relevant factors, and how to document verification of income and assets, and how can you most easily and smoothly kind of transition from what you're doing now to what that would require. Maybe a lot of us have just been relying on desktop underwriter or loan prospector, and we know we have a QM, but that is not necessarily going to carry you through, or at least it's unclear on how much you can rely on those underwriting reports to get you through the new QM. But on the next slide, let's talk about what that new QM will otherwise look like. Instead of a DTI threshold, a QM will largely be defined by the loan's pricing to the consumer and whether the APR exceeds the average prime offer rate by 2.25 percentage points or less. The new QM would still have to meet those other elements, such as the limitation on product features, points and fees limits, and the distinction between the safe harbor versus the rebuttable presumption QM that was based on the loan's APR from the prior definition. On the next slide, I want to talk a little bit about something that will be different going forward for what we're calling short reset arms. So the QM rule would impose a special requirement for those arms, those for which, excuse me, for which the rate may or will change within the first 5 years after the date on which the first regular payment will be due. So in order to determine whether those arms constitute QMs under the new rule, we would need to know what the APR is. For that purpose, and just that purpose, the creditor must look at the maximum rate that will apply or may apply during that 5-year period and sort of pretend that that's the rate that would apply for the life of the loan. Then you compare that APR to the APOR to determine whether the loan is a QM and whether it is a rebuttable presumption QM or a safe harbor QM. So that will be interesting because that's a different APR. That's not the APR you use for HOPA high cost purposes. That's not the APR that goes on the closing disclosure. This is something that you calculate merely to determine whether or not the ARM is a QM. So the rules would provide for a period of overlap. The current QM, the 43% DTI, and the Fannie Freddie patch QM are scheduled to remain available until July 1st, 2021, at which point those two categories would, under these rulemakings, go away, and QMs would be determined largely based on this APR spread concept. However, creditors can begin using that new APR concept if they choose beginning March 1st. So there's a period of overlap. Next slide. So here I wanted to talk about quickly point out one aspect of the current kind of QM regulations that is going away. For a period of time, the regulations allowed creditors to cure a mistake in calculating the points and fees. So if the loan inadvertently exceeded the 3-point threshold, the creditor could refund the amount relatively quickly in order to sort of restore, preserve the loan's QM status. That cure provision had a deadline, which has now passed for new loans. So starting with loans that were consummated on or after January 10th, unfortunately, we can no longer rely on that cure provision to fix the points and fees. On the next slide, there is a sense in which a loan can become a QM under this separate rulemaking that the CFPB issued. Loans that have experienced timely payments for 36 months can become a QM if the loan is not securitized within that 36-month period of time. So this seasoned QM category will allow first lien fixed rate loans, so not ARMs, fixed rate loans, to become a safe harbor QM so long as it meets these other kind of standard factors: fully amortizing payments, loan term does not exceed 30 years, points and fees do not exceed 3%, or the limit that applies depending on the loan amount. And importantly, the creditor must still have considered DTI or residual income and verified the debt obligations and income in the same manner that it would have if it were making a QM loan. So still can't get away from those requirements. And on the next slide, as I mentioned, there is also one other catch. A loan can only season into this QM status if the originating lender holds the loan in its portfolio for that 36-month period. Or the loan could be sold once during that period, but not securitized as part of that transfer. So it really is sort of putting the onus on the creditor to be sure that it is underwriting the loan in accordance with the rule. What constitutes, this is on the next slide, what constitutes 36 months of timely payments? I have the parameters here. No 60 or more day delinquencies, no more than 2 30-day delinquencies. One other catch, this doesn't apply to pre-existing loans. It would only apply to loans for which the application is received by the creditor on and after March 1st. So as I mentioned, you still are going to need to have followed the underwriting and verification requirements. So in a sense, for several reasons, this seasoned QM category may have really limited utility. It could be helpful. We mentioned those short-term ARMs. It may be helpful for those to kind of mature into a safe harbor QM, but it's kind of hard to see what other daylight this season process will help with. As Rich mentioned, these rules were published in the prior administration, but are not yet effective. And the CFPB has indicated that it's considering what to do, whether to freeze these rules, since they were issued in that pending period of time. So we haven't heard yet. March 1st is obviously just a couple weeks away. I have heard some rumors that the acting director will, in fact, extend the 43% DTI QM and Appendix Q, and also will extend the Fannie Freddie QM for a period of time. I also heard that perhaps this seasoned QM category could be frozen for further consideration. So I looked today, Rich has got some tea leaves that he's reading. Every day I check, so I haven't seen any official pronouncements yet, which is tough because I know we're all trying to figure out what to do starting on March 1st. Certainly we can continue what we're doing until July 1st, but it would be nice to know. So with that, that's it for QM, although of course I'll be here for any questions.
Hi, I'm Natalie Vance from Klinedinst PC, and I just wanted to do a quick employment law update. For those of you who were at the Legal Issues Conference, some of this you've heard before, but my focus here today in the next 5 to 10 minutes is to really review the things that you should be doing right now in light of new laws that took effect in January. So hopefully you have already done these things, but if not, there are things to be doing immediately and be thinking about as some deadlines are coming up. Next slide. So the first thing I want to talk about is pay data reporting. If you have 100 or more employees, you have to submit pay data reports to the Department of Fair Employment and Housing by March 31st. And so that data is going to include information on the numbers of employees by race, ethnicity, and gender, who are employed in specific job categories, and then you're required to provide the W-2 pay data information for them from the 2020 year so that the DFEH can analyze that data and identify potentially discriminatory pay problems. So this is going to be an annual requirement, but it starts this year, and March 31st is the deadline. The DFEH has published a user guide that provides information on how to report the data, as well as an Excel spreadsheet that you can use to fill in the data and provide it in the format that is being requested. So there's templates available on the website. I have a link to the website here on the slide. So definitely make sure that you're on top of that. Again, the deadline is coming up in just a few weeks here. Next slide. Additionally, the California Family Rights Act has been expanded this year. It used to apply to employers with 50 or more employees in California, and now it applies to employers with 5 or more employees. So vastly increased the number of employers who are subject to the California Family Rights Act. And one of the requirements of the act is that you have a written policy which explains the rights available under the California Family Rights Act for employees. And every employer 5 and above must have this written policy. And if you already had a written policy because you had 50 or more employees and were subject to the act previously, that policy needs to be updated because the law has been expanded not only to include more employers, but also to expand the number of close relationships that would be applicable under the act and to erase some previous limitations. So the California Family Rights Act provides for 12 weeks of unpaid leave for an employee who has been with the company for at least 12 months and has worked 1,250 hours during that past 12-month period before they request the leave. And that's now expanded again to all employers, but it's for a serious health condition of the employee or a close family member. And close family member has been expanded to include grandparents and some other family members that you're going to want to make sure are included in your policy, such as grandchildren and siblings. So that's broader than it was previously. You're going to need to change your policy if you haven't already. Next slide. Additionally, it eliminates some rights. You used to be able to designate key people who would not be subject to the unpaid leave. You can no longer do that. So if you were doing that previously, even your key employees are entitled to the 12 weeks off. And you used to also be able to combine leave for baby bonding. If both of the parents worked for the company, you could require one 12-week period that would be shared by both parent employees. But now each parent is entitled to the full 12 weeks of unpaid leave. So if your policy has language in it that allows only for 12 weeks for both parents, you need to change that as well. So again, immediately update those policies if you haven't already. And then next slide. The last thing I wanted to address is the new Cal OSHA regulations, which essentially went into effect earlier this year. This is for when you have an incident of an employee testing positive in the workplace for COVID. There are now new regulations which require you to investigate it, notify other employees who had contact with that employee, ensure they get tested, and make sure that anyone with a potential exposure or who has tested positive get 10 days of paid leave. The key here is that this requirement also includes a requirement that you have a written COVID policy, and that policy must comply with the new Cal OSHA regulations. So if you have not updated your COVID policy in the workplace, now is the time to do it. There is a sample at the Cal OSHA website, and I have a link to it here in the slide. You can actually download a model policy and use that to ensure that you have all of the Cal OSHA requirements in your own policy. You also are required to have a specific policy for each location where you have more than one employee. So if you have more than one location in California, you have to have a separate COVID policy that is site specific for each location. And I will tell you that this is an area that I can expect we're going to see some enforcement on. I have a client who received a request for documentation on wage and hour compliance from the Department of Labor Standards Enforcement. And in that request, they also asked to see the COVID policies. And so if your policies are not in compliance, we can expect, it looks like these state agencies are working together to ensure that you do have the documented COVID policy that is in compliance with the new regulations. So definitely take a look at that and update those policies. And that's all I have. Thank you very much.
Okay, well, this is Mike Flynn. I'm going to speak now on specific COVID-19 related mortgage issues that have been arising. If we could go to the next slide, please. Goes without saying that the COVID crisis has created really unique and unparalleled economic and social disruptions in terms of unemployment, underemployment, people unable to make mortgage payments. The length of time, it's already gone on far longer than we expected. It's going to go on quite a bit longer. And this is creating all sorts of issues related to regulatory oversight and requirements in regard to mortgages, particularly mortgage servicing. Next slide, please. We've seen the government starting last year, very early, last March and April, getting very active here in terms of protecting particularly residential homeowners and mortgage holders in regard to COVID issues because of their inability to perhaps make mortgage payments and tenants making rental payments. As Rich indicated a little while ago, the acting director of the CFPB has indicated their interest in making sure that COVID-related issues are handled properly. And we've seen the California, the now Department of Financial Protection and Innovation, announcing recently that it's going to include COVID-19 requirements in its examination protocols. These are examples of governments really taking strong actions. Next slide, please. We've seen this type of activity not just from the CFPB and the California Department of Financial Protection and Innovation, but all the federal banking agencies and the CFPB issued guidance as early as last year encouraging banks to, within safety and soundness sensibility, work as much as they could with borrowers on forbearance and avoiding defaults and that sort of thing. State regulators, including the then DBO, now the Department of Financial Protection and Innovation, the Washington Department of Financial Institutions, and the Oregon Department of Financial Regulation have issued similar guidance. Next slide, please. As a result of all of this, we have seen specific requirements come out in regard to mortgage servicing issues in the area of forbearance, and also in the area of foreclosure and eviction moratorium. Let's start with forbearance. The GSEs and federal agencies, Freddie, Fannie, FHA, VA, U.S. Department of Agriculture, as a result of the CARES Act requirements, have extended the time period for seeking forbearance. It says until March 31st, but given how quickly and often the government is moving here as this crisis goes on, we just saw this morning the announcement that at least Freddie and Fannie are extending the time for which you can seek forbearance up to the end of June of this year, and extending it and providing an extra 6 months in addition to the original 12 months if you have a pre-existing forbearance dating back to, I think it's last June. You can carry it forward for essentially 18 months instead of 12. And you can expect that the other agencies, if they haven't already, the federal agencies are going to do the same thing here that Freddie and Fannie have been instructed to do. And I just want to remind you, if you're working in these areas, not just COVID requirements, there are also the general forbearance and post-forbearance process requirements that are still in play that the CFPB will be looking at, as will these agencies, Freddie, Fannie, and FHA requirements, the rest of the servicing rules, the California Homeowners Bill of Rights, which we'll talk about a little later, and California's AB 3088, which contains various forbearance requirements. And other investors have their own. Let's go forward to the next slide. I want to talk specifically for a minute, very briefly, about California AB 3088, which was passed the end of last August at the end of the 2020 legislative session, and then SB 91, which is a recent update to that, to the requirements. It has both tenant protections and general forbearance protections. In regard to forbearance, it requires now that if you receive an application for forbearance and you deny it, you must provide written notice to the borrower. And if the defect is curable in the application, you must notify the borrower and give them time to provide more information. There is a safe harbor which says that if you comply with the CARES Act forbearance requirements, even if you don't have a federally backed loan, but if you comply with those requirements, you'll be deemed to comply with these forbearance process requirements. So something to keep an eye on. If you're working with FHA, VA, Freddie, Fannie loans already, you probably have no issues here. If you're looking at portfolio loans that you're holding or selling to private investors, you want to pay attention to this. Let's go to the next slide. These two bills also contain requirements for after the forbearance period ends, kind of vaguely worded. It says a mortgage servicer shall comply with applicable federal guidance regarding borrower options following a COVID-19 forbearance. Not defined what that means. Not defined how that would work. If you don't have a federally backed loan, what applicable federal guidelines apply? Obviously, you have the RESPA servicing guidelines, but is there anything else, whether they're intending that you should incorporate other federal guidelines, isn't really spelled out. This is really only an issue, I think, again, if you are working with portfolio loans, because otherwise you're already following these GSE and federal agency requirements. Let's go forward. There are some questions here about what's going to happen with forbearance down the road. And I'm not going to spend a lot of time talking about these. I just want to point them out to you that when the mandated forbearance periods end, what's going to happen if someone has a permanent hardship? If they have, during this time period, lost their job and could never get the same job back, unfortunately, or couldn't get as high paying a job and really have long-term problems. What about how you handle things like repayment options, liquidation options, future loss mitigation efforts? I think we can expect to see in the future Freddie, Fannie, federal agencies, state governments, California particularly, putting forth some new guidance down the road on how this is all handled, because this is a really kind of a new world when we start coming out of the forbearance periods here as the economy picks up. We're going to have a lot of people who are not being able to ride that wave of the economic stability back up, and we're going to have to figure out ways to deal with them, and that's going to fall on mortgage lenders and servicers. Let's go to the next slide. There are other issues as well, such as when if there's a second round of shutdowns or even more business shutdowns, if the COVID gets worse, we're going to see another wave of requests probably. Issues regarding second forbearances and post-forbearance options and such. As I said, I think we can expect to see a lot of regulatory action in this space. As we move through the COVID crisis and seem to be heading out of it, I think we can expect to see efforts to define for mortgage lenders and servicers what needs to be done for those who are being left behind. Let's go to the next slide. All right, evictions and eviction moratorium. Let's start first again at the federal level, FHA, the GSEs, VA, Department of Agriculture. Again, when I prepared this deck last week, I said it was extended to March 31st. Now, of course, at least for Freddie and Fannie, it's been announced today it's going to June 30th. Likely the other federal agencies would follow in regard to both foreclosures and REO eviction moratoriums. I think we can expect that's going to be in place. That is, by my count, the fourth or fifth extension, at least for Freddie and Fannie on these guidelines. So I think we can expect that if COVID continues, that June 30th is also a moving target. It's going to keep moving out. It's going to keep moving out until this crisis is really deemed to be over at the federal level. When that is, obviously, no one knows. I should point out that the Biden administration, even before President Biden took office, their stimulus package they proposed has an extension of forbearance and eviction moratoriums until September 30th. And even that won't be where we end if the crisis continues. It's going to keep moving. There's just no question about that. Let's go forward. Next slide. All right. tenant eviction moratoria. There's a lot of things in this area that, while it may not seem to be directly related to residential mortgage lending, I think it's an issue where if you're a lender and you're looking to foreclose or considering foreclosure or capable of foreclosing on portfolio loans, or later, if there are some loosenings of restrictions on foreclosures from the other agencies and GSEs and investors, you need to consider tenant evictions where the property was a rental property. It was a second investment property for a borrower, or became a rental property for a borrower while they were your borrower, or at the last minute they move a tenant in trying to protect themselves, and then you have to consider whether state law makes that person a tenant from the lender's perspective when they foreclose. But if in fact you have tenants on the property, particularly a rental property that you foreclose on, you have tenant eviction moratoria that from the CDC that is nationwide. It's to at least March 31st right now. Just recently they updated that. That's going to go forward again, I suspect. And there are several requirements a borrower has to meet, the tenant has to meet. Basically, they can't pay their rent, they're facing real hardship, there's a risk they could end up homeless or move into shared living, and then have income restrictions, essentially not making more than $99,000 as an individual or $198,000 as a joint tax return couple in 2020. And if so, there's a ban on evictions. This isn't a major issue, again, because of the agency and federal government requirements for anyone except in the area of portfolio loans, where this would still apply. Let's go forward to the next slide and talk about the next evictions moratoria issue. We see a lot of evictions moratoriums at the state level. We see that, I'll talk about California in a minute, but Hawaii, Oregon, and Washington have imposed state moratoriums, and many local jurisdictions have their own. We don't have time to go through every local jurisdiction, even in California, but as an example, San Francisco has a ban on no-fault evictions until March, and no doubt that and every other local jurisdiction that has these type of restrictions will be extending them as the crisis continues. Let's go to the next slide. All right. California addressed evictions in AB 3088 and SB 91, which we talked about a minute ago in regard to forbearance. Very detailed and complex requirements here in regard to evictions. Originally, the basic idea is that if a tenant responds to the notice to quit and other notices required under these bills with a hardship declaration, a COVID hardship declaration, the landlord cannot evict for non-payment of rent from March 1st through August 31st of last year. And if the tenant delivers the hardship and starts paying 25% of rents due from September 1st of last year through July 31st of this year, you can't evict them. You can't even bring an action or start a non-judicial foreclosure. They're just, I'm sorry, not foreclosure. You can't do a UD following a foreclosure. And in general, you can't bring any unlawful detainer related to non-COVID rent arrearage just cause events until July 1st, and for COVID-related failure to pay rent August 1st. So effectively, you have real restrictions. I should back up and say I'm not actually sure that's accurate, that comment about July 1st for non-COVID rent arrearages. I apologize, I just noticed that. So, but there is a restriction through August 1st for failure to pay COVID-related if they provide the hardship. Let's go to the next slide. So another interesting aspect of AB 3088 that doesn't get a lot of coverage is that, as you know, the California Homeowners Bill of Rights provides lots of protections in regard to first lien mortgages or deeds of trust secured by residential property occupied by an owner. Similar to a lot of the RESPA servicing rules, they provide need for single points of contact, various notices, a lot of things. Well, SB 308 has expanded many of the provisions of the California Homeowners Bill of Rights to a first lien mortgage or deed of trust secured by tenant-occupied residential properties with no more than 4 dwelling units, and it has to meet certain criteria. Essentially, the tenant is unable to pay rent due to a COVID hardship. But this is a big expansion and gives, what it's designed to do is to give borrowers who are landlords, who are renting out, say, a second home or a duplex or something, the protections of the California Homeowners Bill of Rights during this crisis, because the legislature was very concerned that they need extra protection, even though it's not their own residential property. It's a tenant resident property. They don't want disruption of tenants or anyone else being evicted or bothered right now in this situation. So they've expanded these rights to those to the borrowers in those types of properties. So something to keep in mind. You wouldn't normally think of it in terms of application of the Bill of Rights, but you have to now. Let's go to the next slide. That's really all the specific COVID-related rules that have been put in place in regard to forbearance, foreclosure, eviction, expansion of the California Homeowners Bill of Rights. All I wanted to wrap up with is where are we headed? And again, the real point is down the road here, we're going to see a lot of people continue to have hardship, even as the economy continues to pull out of the restrictions we have and continues to grow and create employment opportunities. Not everyone will come along at the same speed or have as much, will get their economic situation improved at the same time. So the real questions are, how long will these programs continue? If they do continue for a long time, how are the agencies, the federal government, state governments going to address the economic impact on lenders and servicers, and at the same time, while at the same time protecting residential borrowers and tenants? And then there's another question of, will many of these programs become permanent in whole or in modified versions? A good example is, we're going to have a discussion of Senate Bill 1079. I don't want to go into it except to say that while it's not specifically COVID related, it was passed during the COVID crisis, which no doubt had some impact on it, but it's a permanent foreclosure rule now in California, and we may see more of that with these other rules as well. It's something to keep an eye on and for you to get used to in the world in which we live. Thanks, that's all I had.
Great, thank you there. So we'll actually do a little bit of a dive into 1079 specifically here, and Michael makes a really great point, which is COVID is its own cause, but affordable housing appears to be kind of intertwined from a legislative and policymaking perspective, and that's what you're really seeing here with 1079, which is tackling two issues at the same time. So if you can go ahead and click over to the next slide, kind of do a quick dive into what 1079 did. Go ahead, next slide. Big picture, it went into effect in January 1 of this year. It applies for a period of 5 years, could obviously be extended beyond that. The big challenge here and what shifted this is that it applies to, it just looks to asset class. So if it's a 1 to 4 family property, if there's a dwelling that sits as the collateral for the loan, then this new regime applies. And so high level, what this bill does is it permits certain parties to purchase a property after the foreclosure sale is done. So traditionally in California, like any other state, you have a foreclosure auction. The foreclosure auction, barring any sort of irregularity, was final in nature. And so what happens now is there's this basically, post-foreclosure auction period in which a third party can now intervene and potentially purchase the property from the original purchaser at auction. Next slide, please. So they basically created this class of what we call eligible borrowers, eligible bidders. An eligible bidder can be a prospective owner-occupant, so someone who intends on purchasing the property and occupying it as their primary residence. There are preferential rights, and I call kind of super eligible bidders, which are these current tenants at those exact same properties which were foreclosed upon, who have extraordinary rights. And then there's other eligible bidders. So, for example, certain nonprofits for that primary purpose is affordable housing. You've got the state of California and other sort of government agencies, which are also considered these eligible bidders that have these additional rights. Next slide, please. So I'll kind of give you a few different examples of how this is going to manifest and play out, so you can kind of see in real time how you foreclose in California on dwellings and how it's changed based on this new regime. Next slide, please. So the first example that we'll give here is that these eligible bidders can actually show up to the auction. So like we talked about previously, is that if you were at the auction, the result at the auction was conclusive in nature previously. And similarly, if one of these eligible bidders, right, so either a person who is intending on occupying the property as their primary residence, or the tenant of the property, if they're actually at the auction and they are the highest bidder at the auction, they end up the conclusive final owner, and it ends the process. So in theory, you could have a situation that arises in which the auction is conclusive the day of. This party would have to submit an affidavit stating that they are this owner-occupant that are going to occupy the property. But once they provide that, the auction is conclusive and it ends any sort of post rights to any other parties. Next slide, please. So here's the one that's probably the most interesting and I think the most concerning as a mortgage lender. So previously, if we're going to counsel a mortgage lender that's going to be foreclosing on a property, we would talk about your bidding strategy at time of foreclosure sale and the recourse you may have, so particularly against a potential guarantor. And so there's always this tactical game of what should your opening bid be, how your bidding increments all the way up to the final max credit bid or whatever maximum bid the lender should take based on the facts behind the situation. So what's really interesting and probably most scary about what's happened with this bill is the treatment of a tenant purchaser. So the tenant at the property can see what happens at the auction, and they've got a 15-day window where all they have to do is match whatever was the final bid at auction, right? So in a previous rule, that could have been the minimum opening bid, could have been half the loan amount, whatever this thing started at and finished at auction, right? So as long as the tenant is willing to submit a bid saying, I'm willing to pay that price, right? The property could have gone back to the lender, it could have gone to a third-party purchaser. As long as the tenant submits what's known as a bid to the foreclosure auction or to the trustee, stating that they intend on purchasing the property at that price, they are now given a super priority. So as long as they're willing to consummate that purchase within a 45-day period from date of auction and submit a bid within 15 days from date of auction, they are now, and it's assuming they can consummate within that 45-day window, they then get ownership of the property. They take it back from the owner who gets it at time of foreclosure sale. So they're the ones that get the most extraordinary rights from an eligible bidder concept. Next slide, please. So then there are these other eligible bidders. So there are these prospective owner-occupants, as well as other nonprofits and other organizations which are considered eligible bidders who are not the current tenant. Same thing, they have 15 days after the completion of the foreclosure auction to submit a bid. The bid needs to be higher than the final foreclosure auction price, but they can be 1 penny higher or whatever it might be. So they can submit any price, any bid that's greater than that. It's basically a blind auction at this point that's occurring in the background. You have this 15-day window that occurs, and any party who qualifies within the statute here as an eligible bidder can submit a silent bid basically over to the foreclosure trustee and say, I actually want to purchase property for a greater price than it was sold for at the foreclosure auction. Similarly, they also have a total of 45 days to perform. Performance requires a cashier's check sent into the foreclosure trustee within that 45-day period, so that is a pretty big limiter there. But as long as they're able to provide good funds to the foreclosure trustee within that 45-day period, then this third party now gets ownership of the property at time of foreclosure sale rather than the original parties at time of foreclosure sale. Next slide, please. So this next example is you have a foreclosure auction and no eligible bidders, so no tenant, no eligible bidders of any kind end up bidding that 15-day window. The auction is now conclusive after that 15-day window because no eligible bidders started bidding at that point. So now you can have a transfer of title that occurs about 18 days or so after the auction. Next slide, please. And then you have the last example that's probably probable in the situation here, which is that you have someone who ends up bidding in that 15-day window, but they never actually consummate the final purchase, right? They're unable to get funds into the foreclosure trustee, so they submit a valid bid in the 15-day, but ultimately can't perform within the 45-day window. And similarly, it would go back to the original party who got the final auction at the day of auction, and it would revert back to them as well. Within these fact patterns, you have all sorts of crazy circumstances that could arise. You could have fire loss. You could have all sorts of things and you know, fun legal quagmires that occur because effectively you have a party who is presumed to be the owner at a foreclosure sale, barring one of these things from happening, and then who may in fact lose their rights to the third party who doesn't get any rights till the 46-day from an ownership perspective. And so you really have this weird 45-day holding pattern and all sorts of challenges that can arise from final date of auction to either the 18th day or the 48th day, depending on what happens in the facts here. So well-intentioned bill, I think, from an affordable housing perspective and trying to do this. From a mortgage lender's perspective, ultimately, I think most mortgage lenders' response to this will be opening bids are now going to be max credit bids, more likely than not, because ultimately, if some third party can come to your auction, bid 1 penny more than whatever the final conclusive price was, and end up owning your property, even though your loan was never extinguished or paid off in this time period. So definitely some potential issues, particularly for those that are just not well versed about what happened here in California. Next slide, please. So a couple of things to take note in addition is that the notice of sale has additional language that must be included in the notice of sale. You would not have to re-record it if the original notice of sale was recorded prior to December 31st or on or before December 31st of last year. But anyone that was recorded on or after January 1st would need to include additional language regarding these additional tenant rights and owner or eligible bidder rights. The law stated that it does not modify or expand or contract any sort of existing rights that a tenant may have. Trustees now have additional requirements on their website. So, for example, trustees now must post that final auction price, permitting other parties outside in the world to go ahead and see what any particular property traded at time of foreclosure sale. And so that was traditionally aggregators like Property Radar or otherwise that had that information, but now the trustee must post it on their own website. And then very large fines were implemented as part of this as well, related to vacant properties or nuisance properties. The legislature very much does not want a mortgage lender to come in, foreclose on a property and just leave it there and let transients or otherwise kind of take over the space and cause issues to the neighborhood. So significant fines were added as part of the statute as well. Next slide, please. That's all I've got. Thank you.
And right now we're near the end of the session. So what we think the best thing to do is if you do have questions, here's the contact information directly for our speakers. I want to thank each of our speakers today, and they'd be happy to address any questions you submit in contacting them. Few word crystal ball on QM, what do we do? It's February 16th. If the Bureau is going to delay it, they've got to do something soon. I would stay the course. If they delay it, then we pause at that point and decide what to do. It's hard to implement a rule, so I would keep moving forward, and let's wait and see. Now, if you're a member of the committee, we have our member-only calls, and the next one is coming up 1 month from today. We will then know what has happened with the QM rules come March 16th, and we'll probably have more information on what's going on with COVID and the federal government efforts, and do we have a new federal stimulus legislation? Maybe we'll know that by then. So this will be a busy month, so please join us. If you're not a member of the committee, you can contact the CMBA to become a member of the committee, and we encourage everyone to join and participate. With that, again, I'd like to thank our presenters for fantastic presentations, very informative. It's a busy, busy time going on both at the state and federal level, and we're likely to see now that legislatures are getting back into session again and getting busy. There's going to be a lot more COVID-related legislation coming down the pike, both federal and state. So please stay tuned to the California MBA for updates, and also look for advocacy requests, because we probably are going to need to advocate positions for the industry before the legislature and the National Mortgage Advocacy Alliance. Doing it at both the national level and the state level is very important. With that, I wish you all a pleasant remainder of your day.